Well, we've laid out a number of very interesting issues. Before I open it up to you all for questions, I wanted to give our panelists just a couple of minutes to provide follow-up commentary on any of their co-panelists' comments. And we'll start with you, John.
Where to begin? I'm going to focus on Paul's comments. It's probably going to be a shock to everyone. Geez, where to begin? Let's go with 2 points. And the first one is this. I appreciate the economic analysis, and I appreciate the reference to privacy not being a free lunch. But typically speaking, when we talk about long-held constitutional rights and common law rights in this country within the legal system, we don't analyze them and make proposals to discard them or regulations that implement them based on purely economic analysis. There are lots of constitutional rights that we treasure in this country that are quite expensive in actual implementation, and the regulations enforcing them are quite expensive. So that would be my first point. I don't think that the economic analysis tells the whole story here. The second point would be, you asked a few times where the harm was, and
I'm sorry?
Where the harm was, where the privacy harms are here. And I just, what bad could happen when we're talking about this sort of information that's available? What's at stake? What's to lose? A couple of examples. 2 weeks ago, a Facebook user lost her healthcare benefits because her Facebook profile, which was, according to her privacy preferences, restricted to only her friends, was accessed by her health insurer. Her health insurer revoked her health benefits, which she was receiving for serious clinical depression because she was smiling in her Facebook photos. She looked too happy to be really depressed. So that's something that could happen. A man in New Jersey had an entry placed in his background report with a private firm, not a government agency, that stated he had kidnapped his wife. He lost his job and spent the next 4 or 5 years litigating the issue between the private firm and the government agencies, each pointing fingers at each other, saying, it's not our fault, it's their fault. If you want this data to be removed, you need to go see them. So you can lose your job, you can lose a lot of money, there can be issues there. These are the sorts of very serious things that are at stake when individuals don't have the right to access and correct their information, when individuals set privacy preferences and enter into trusted relationships with corporations, and then that information is communicated to others without their consent. So I would just make those 2 points and then move on.
Yeah,
Okay.
Can I respond?
Do you want to take,
I think I would, if I
Go
could.
ahead.
As far as the constitutional point, you can argue it both ways, I think. There are First Amendment issues there. I've read the Constitution, and I don't see any reference to the Internet. So clearly, we're going beyond whatever constitutional protections there might be and trying to decide how do we want to extend the Constitution here. I actually have a paper on the cost-benefit analysis of the Bill of Rights arguing that most of the Bill of Rights does, in fact, have cost-benefit tests. You free speech, but you can't yell fire in a crowded theater. What is that principle? That's a cost-benefit principle. The speech there is not sufficiently valuable, and the First Amendment is actually riddled with cost-benefit tests, if you look at it. But here we're extending the First Amendment. I'm a First Amendment an absolutist more than many of you. I worked for the Federal Trade Commission in the advertising division, and I viewed my job as wholesale violation of the First Amendment, which doesn't distinguish, as near as I can tell, between commercial and other speech, but we do in policy. The examples you gave are, I think the ground is sort of shifting. What I've been talking about is the anonymous use of surfing information, of internet information in advertising. Personalized information, health information, Facebook, I don't do Facebook because maybe I'm afraid what they would try to sell me, but information of that sort is totally different, may deserve some kinds of protections, but the examples that I see examples like that all the time, but they're not examples of surfing information used for advertising that has caused any harm. And neither example that you gave was an example of surfing information of the sort. I click on this website, Google sells that click to somebody else. Where's the harm?
No, it is. They aren't, but they're exactly the sort of information that go to your example of health information being provided to a marketer who may want to market a prescription drug that you might be interested in. And that's your example, so that's not mine.
If that information is then sold to a health insurer for personal purposes, that's a different thing. Was the information you gave was not someone clicking on a website about depression. It was a totally different piece of information.
Right, so I think there's a distinction in the types of privacy protections we're talking about and the types of data.
Sure.
So Lisa has asked me if she can comment next, so I'm going to turn it over to her.
Well, far be it from me to take the privacy advocate position.
Welcome.
But Paul, you make it hard. A couple of points. First of all, many of the companies that I work with, and I work with very responsible marketers, do in fact link cookie data to personally identifiable data. So where you register, for example, on a site, they will link the registration data to the cookie, so they'll follow you across the internet and sometimes know who you are, and often not, but they can or have the ability to do it. In addition, IP address certainly is something that is up for grabs right now. The FTC has specifically and pointedly stated that the distinction between personal information and non-personal information is much more gray than we originally thought it was, and something like an IP address is really in the gray zone because, yes, it identifies a computer, not a human, but often that computer can be identified with a human. Second point is, you mentioned that identity has low value, 40 cents or something for a credit card number. That, to me, does not suggest that there's a low risk of harm because it's a low cost, but instead suggests to me that data is so ubiquitous. There's so many credit card numbers that they sell for a low price. There's so many Social Security numbers out there. If you ask the Secret Service what they'll tell you in a half, what they will tell you is that your data is not really at risk. Why? Because it's a needle in a haystack. There's so much data out there that the hope is that yours won't be used for nefarious purposes.
We did some cost calculations once, and the cost of having being identified as a person whose information was stolen is somewhat less than $10 based on the FTC's data. So when you get a notice that your information was stolen, the rational thing to do is probably nothing. Maybe watch your statements a little more carefully for a month or two, but the expected cost is really very low. I think part of what we've done is we've over-scared people about identity theft and probably kept them off the internet when they'd be better off doing more stuff on the internet.
Bruce, can you jump in?
I'm not sure how to unify all this, but one word that keeps popping in my, I'm sure I can do it in 30 seconds. One word that keeps popping in my mind is invisibility. The invisibility of the tracking and targeting that is now enabled by these new technologies. And so let's separate a breakdown in the system. Look, if a policy or practice of a company is such that it shall not share information that is personal health information, etc., with a health insurer, and that happens, that's a breakdown in the system. And we should avoid that. But I, to a certain extent, I analogize that to a data theft, or me losing my laptop in an airport, and all of a sudden now all the information that's on there is potentially exposed, and we've got to do something about it. So if I put that aside, I want to focus on things that aren't a breakdown in the system, but that may or may not, that may still not be okay with you. What I'm talking about is when a policy of a search engine or some internet company allows them to do certain things. Take your voicemails that you've created in connection with some new digital voice service, take that digital voice and transcribe it automatically through some processing system, and then make that part of a search engine's results. I mean, the point is, your voicemails, your now digitized and transcribed voicemails, are part of a search result. It sounds far-fetched, but it has happened. But the key is that in some of these circumstances where you would look, wow, that's surprising to me. I really wish my voicemail or this part of my information was not available, fit within the privacy policy that you were operating under, that you might have accepted, that you might have opted into for all you know. But the fact of the matter is, because this privacy policy was so arcane and divided up into segments and impossible to pin down because it was cut up over different services, that you had no idea. Yet nobody broke a policy. No policy was violated. The benefit of the bargain theoretically was satisfied. And what's your recourse? Our view is, aside from a breakdown in the system, let's get away from that. Maybe you can argue there's no harm. It's just your data. You know, if you're not a bad person, if you're not a terrorist, if you're not doing illegal things, what are you worried about? I mean, I've heard that argument. But at least know what's happening with your data. And you can make an informed choice. You might say, there really is no harm. I'm really not that interesting a person. I mean, you know, have at it. I mean, that's basically my view of the world. There's not that much that I'm doing that's that interesting, but others might feel differently. But you and I, where we have different views, we're both operating on less than perfect information, where things that are happening with our data might fall within somebody's privacy policy, but you didn't know about it because it was presented to you in such an unhelpful way. So I think short of a breakdown in the system where your data, which was never supposed to go to place X, went to place X, and that's a different issue altogether. I think short of that, we still have some challenges in making sure that your expectations are met. And that's probably worthy of some work, because whether technically there's harm or not, or we could look, I'm a litigator. I'm all about, you know, prove the damages or go away. But we all have different expectations. And we're all entitled to figure out how our expectations are met in an online environment. And the only way you're going to be able to do that is with useful information.
Okay, I want to leave some time for questions. Before I do that, Kirk, I wanted to give you an opportunity if you have any follow-up points to make at all.
I would just agree with Bruce on his point. At the end of the day, companies like Walmart, we are serving our customers, and it's all about giving that transparency and control to the customer. So that puts us in the middle of the discussion of the advocates and the cost-benefit analysis. But at the end of the day, it's about our customers.
Thank you. Are there questions out there? It's been a very lively discussion, so go ahead.
Yeah, I have a question. John Stoutner is my name. I had a conversation last night with one of the judges here, and we were talking about how all of the court information is being put online. And the court information, which may have always been public, quote unquote, but in the past you'd have to go there in order to retrieve it. Now all of a sudden, all this information is online, searchable, indexed, and some of it can be quite sensitive. He was giving me the example of a messy divorce case that maybe the kids didn't need to know certain details about this, and you can sort of imagine what else might be made available that is public information, but now widely and very easily accessible, and what people might do with that.
Just very quickly, we've been involved in that issue in Washington, D.C. We actually worked with the D.C. courts in order to redact Social Security numbers and other information regarding minors from the family court records. There's really a dual interest here. There's the interest in transparency, which is incredibly powerful, and there's also the interest in privacy. And privacy doesn't mean secrecy. We don't have secret courts in this country. Privacy means being able to control your information. And when you have individuals who have voluntarily engaged in litigation, or if it's criminal litigation, done something to get them engaged in that litigation, then our view is that it kind of falls on the side of transparency. Having said that, there is sensitive information like date of birth, social security number, things like that, that ought to be redacted as a general matter of civil practice, and often is. The issue is generally with the older records.
So on the question of harm, I represented a company that was going through bankruptcy proceedings. The company posted the social security numbers as it was really required to do, although they might have taken more care, 55,000 social security numbers. At least half a dozen of those people had their bank accounts wiped clean as a result of that posting, and it was a direct result of that posting. So bad things can happen as a result of court filings being posted.
One quick thing, it's somewhat related to this is, you know, we've been talking about harm now, and I think that's a complicated issue. We probably need to give some more thought to, but I have observed the use of data by internet companies, by search engines, et cetera, that if my company were to use that data in the same way, would probably be a violation of the Wiretap Act. Now, I'm not saying that I'm not saying that we change the law. I'm not sure how to change the law, and I'm not a big advocate of greater regulation. I'm sure you'd be shocked to hear that. For anybody, for that matter. I think that's, you know, you gotta be careful there. But if that's the case, why in the world, when there's no particular difference between, it's like a switch difference, a difference in basic technology, but to you, what difference does it make to you, whether your internet account is with my company or with an internet search company? What couldn't possibly make any difference to you? You don't care what the underlying technology is. But why is it that my company wouldn't be able to do certain things because it would almost certainly be a violation of the Wiretap Act, but some other company could do it? Somewhere along the way, some policy determinations were made about the harm associated with this particular use of data. Are we really going to allow technology choices to create almost an arbitrage opportunity there? I think that's worth thinking about.
Please.
Thank you. One of the things we're asked to do is to approve what's called an investigator subpoena or a prosecutor subpoena. And this usually happens when a police agency is told that there's a stolen computer or an iPod or a cell phone, and the police officer goes to the prosecutor and says, I need more data from an IP, and maybe they have an IP address somehow of a computer. And it's different from a search warrant where we, under the Fourth Amendment, require very specific information. Usually the ones I've seen are very broad. Give me all the data from Verizon or AT&T on this cell phone or this IP address. Do you have any guidance for us on what limits we should consider?
I'm going to get in trouble if I answer that question. Pass. No. You know, that is there's so many different ways that issue comes up, you know, because some of the harms that we are, so take a more extreme example. Law enforcement agency is chasing down an online sexual predator. And they are really getting close to this person. And it turns out they've got an IP address. And do you really want to be the ISP that is standing in the way of getting this person, of associating that IP address with an address or an individual user? You really don't. And that's an easy case, right? Because no one's, arguably, no one's ever going to get mad at an ISP for helping in that circumstance. We could argue over that, but those are easier cases. As you move down the spectrum of reasons why law enforcement might want information about a broadband customer, you know, it gets harder and harder. I'm not sure I have I know I don't have the final answer, but there are, the law does recognize that there are gradations of emergency, gradations of seriousness in the kinds of information that law enforcement needs, and we try to grade them. That's maybe a bad word, but so we can get to the really emergency stuff right away, and then, you know, everything else has to be dealt with, you know, in turn. As far as the amount of information, look, from our purposes, a subpoena that spells out the X, Y, and Z in detail, that is our favorite thing, because we don't really want to be the arbiter of when it's appropriate to turn information over. We just want to help whenever it's possible. We don't want to be in the business of violating somebody's privacy. But I don't think there's an easy answer, frankly, as to exactly what the right amount of information to give.
Do you want to comment, John?
Just a quick note that there is, often what comes into play here are portions of the plain view exception when you're dealing with devices like this, that you issue the investigative subpoena or you issue the warrant, and then there's the question of how plain view applies to the device that's being searched. There's a very interesting Kaczynski opinion out of the Ninth Circuit within the past month that I think strikes a very interesting balance.
Thanks. This will be our last question.
I have a question for Ms. Soto, and this has to do with when you were talking about the e-discovery. We usually think of e-discovery as an issue that comes up once there's a litigation. And I'm talking about with reference to the EU rules being different than ours. Are the transactional lawyers trying to work around this with choice of law provisions in their contracts, or is the EU law not even permitting that?
Yeah, that's a great question. The answer is that any data that originates in the EU, so if it has been in the EU, even if it's U.S. data that goes to the EU and then comes back to the U.S., or data that starts in the EU about an EU resident, that data becomes tainted. And European data protection law applies to that data. So choice of law really is irrelevant. Once in the EU, it's subject to the EU data protection laws, and you need to protect it wherever it is in the world. And one thing that I actually neglected to say, and I want to just make this clear, I talked about a data transfer, the physical movement of data from Europe to the US or another jurisdiction. A data transfer also includes access to data from a non-adequate jurisdiction. So if the data is sitting on a server in Paris and you're accessing that data from the US, that's considered a data transfer as well. So that should give you a sense of how very onerous these rules really are.
Great. Well, thank you. Lisa, you've actually made me more depressed about e-discovery than I've been for the past 5 years, and that's quite a feat. So thank you all for a very interesting discussion. There are a lot of great issues that we'll be grappling with here moving forward, and please, everyone, join me in thanking the panel.